have filed a petition. Well,
problem ಬರಬೇಡ.
either cover or acknowledgement are issued by Honorable Court. I will tell after 9
much times.
3 days.
For the appellant, each time to enable take steps in the light of do it 3 times. I mean, good point. And for the appellant, right? For the appellant subjects that we amended for that but on submission of the county. Complaint status report. Are you able to find out?
All the efforts have been based on she was at home. Morning, at 4:30 she was reading up.
But yes, last week you filed some.
I have already filed my report.
On 20th February 23, you were granted. How much?
Junior Justice Act based my
Fine.
They have also bring a parallel go to the Junior Justice Court in pursuance of section 82 of that. Petition does not comply because
No, last time you took time. See,
I'll
let's
file
file that, then we'll
but
consider.
all the efforts.
No, he's not there. So you are right. It's unethical for us that it is listed for non-filing of further status report, and in his absence, we dismiss the petition on your say. Why you did not argue on the last day to pay? You fought time, right? Why? How much time? Learned High Court comment leader praise fund is granted a week's further time. A week's time to enable him to file further status report. Let's clear out. Office objection. What office objection?
To this one.
Huh?
Petition. Clear. Original.
Counsel for the petitioner praise fund is granted 2 weeks time, 2 days a week's time to enable him to comply with office operations.
Number 8, Harish Kumar MS.
For local. The settlement, raise for dismissal as in
Already. Learned counsel for the parties jointly submit that the dispute between the parties has been amicably settled before the Lok Adalat. In view of aforesaid submission, the appeal is disposed of in terms of compromise arrived at between the parties.
Right. Harish Kumar,
For respondent number 2 in this case, madam.
It has been admitted. What is it about?
Admitted for admitted. Sorry, it was admitted on 10th February.
10th February. So what is it about, madam? You have filed objection. You should say so, right? When we are asking, then only you will tell. Supposing if you would have fixed the date day after tomorrow for final hearing, what you would have done? You should say, right,
Yes,
that
fine.
I want time to file objection.
Yes, fine.
File. So that's what, so everybody has filed. Then. So you don't want to file. Oh, all right. Yes, Mr.
And on the college.
All right. So then we will fix a date for hearing. You are appearing for Mr.
Second respondent college, madam.
Acha. Learned market presence, learned counsel for respondent number 2. And respondent number 3 submit that they do not want to file any objections. Learned counsel for respondent number 1 has states that he has has already filed objections. Line below, in view of found matter of controversy involved in this petition, IA2 of 23 is allowed. Let the same be listed for final hearing on 29th March 23. You are out of course, right? Can you appear? You are not prosecuting the course. You want to appear in the examination, madam. So then. Here, what can be, madam? This is a 23 petition. It has been admitted for hearing by some other bench. We are giving you a date within 10 days. What else can we do? 29th month. But it works, madam, Mr. Correct? It works. The moment we set the date, there was an objection.
application is for posting words. The one for amendment of posting prayer column.
Rectification of office
Two
objection.
applications. So for this posting.
Posting IA. Which IA?
One is for posting, one is for posting. Second one for words amendment of the prayer column.
Yes. What do you say? What amendment?
It also says prayer column.
IA. Mark the presence. Writ petition has already been listed. Therefore, no orders are required. As on IA1 of 23. The same is therefore disposed of. 2 of 23. What is it?
Prayer A. So it's for issue a rate of mandamus and direct response.
All right. Yes.
the approval of the.
Will allow this. Yes, heard on IA 2 of 23, taking into account the nature of proposed amendment and for the reasons assigned therein, same is allowed. Let cost that, let the writ petition be amended within during the course of the day.
The approval of admission words 80% of the orders of example report. Words, respond number 3 is concerned.
When do you want?
Versus, words, 18 words appears for respond number 3.
When do you want you? We are asking you date, you tell us, because the moment we will tell you the date, you will say that I am in Delhi.
We wanted on Tuesday. my lord.
That's the problem.
I'm ready, my lord.
Correct, right? Huh? We can't propose a date because the moment we propose a date, they will say it's not suitable. That's why we are asking first. We don't know.
First, me, show the name. For responding.
No, we don't know. Notice has been issued to remaining respondents. Right? No, at your prayer, we are fixing whatever date you tell, you are saying that it's urgent, therefore we are listing. You tell a date.
That's what. It is on Tuesday.
Learned counsel for the appellant, sub-petitioner submits that the writ petition be listed for orders on admission on, yeah, admitted. Oh, so then why it has been admitted, right? Not admitted. Then
Admitted 13th February.
13 to, it is admitted, Mr. It has been admitted now. What is? So heard they have to file, you have filed objections. Then, how? No, you tell us whether a writ petition can be heard finally without giving, just a minute.
Cannot be lodged.
Please, we are asking you, if you were a judge, what you would have done, tell us. That can we decide the writ petition without giving them an opportunity of hearing and allow and direct that you should be given bonus and dividend and be admitted, they should be sent to jail. What, how that order, will you be able to defend this sort of an order in Supreme Court? Therefore, the petition has been admitted for hearing. We have to give them an opportunity to file objections. So, if they are ready to file it by tomorrow, we have no problem. That's simple. Mr. This all problem arises because you people don't say anything. All right, we take it that you don't want, nobody is saying, as if we are in contest with the petitioner. You people are not saying anything. He is thinking that court doesn't want to hear my petition. You people do, we will say that none of them wants to file objection. We don't know. We don't know.
Sir, you say how much time you want to tell us?
You should have said in the beginning, it's like as if we are appearing for respondents and we are fighting with him that no, we want time. He's thinking that court is not prepared to hear my case.
But expertise are not being done.
What then be done?
Your lordship,
You file within a week, Mr. Learned counsel for respondents pray for and are granted 10 days time to enable them to file objections list on 31st March 2023. Henceforth, if you don't say, Mr. This thing, Ramesh, what is this? You should actually, you are standing there. We are not appearing for respondents. We can hear it right now. What? Yes.
This objection on this you can also. L1 at 8:51. It's right, obviously, we fight. But it is, according to me, it is legible and the only entry that I am relying upon is by submission method. Only indicating.
After hearing learned counsel, this objection is ignored. Third on the question of admission issue notice to respondents.
4 and 5.
One. So then notice on behalf of one and two is accepted by Mr. Lakshmi Narayan, learned government advocate. Notice on behalf of 3. Respondent number 3 is accepted by Mr. N.K. Ramesh. Directed to reflect their themes, issue notice to remove 4 and 5.
In addition. Copies of the file.
You don't know, in addition, the counsel for the petitioner shall be at liberty to serve copies of the petition on the standing counsel for respondents number 4 and 5. If so advised.
Number 12, sufficient malpractice.
What amendment?
With the. Yes.
What amendment?
During the pendency of the law, the appeal filed before the NCI has been rejected. But there are primarily one ground is. But
So we will hear you, you incorporate this amendment today, we will take it up tomorrow, madam. Yes. What?
because I will.
Do it today.
We filed the amended petition.
Yes, yes, fine. We thought you are in a hurry, that's why. All right, all right.
Not happen, I don't want.
No, no, all right. In Parindra Learned Senior Counsel with Mr. Abhishek Mali Patil Learned Counsel. What their presence? Third on IA 2 of 23, taking into account the nature of proposed amendment and for the reasons stated therein, same is allowed. Let amended petition be filed within 2 days. Right? This on when? Yes, madam.
It is not Friday.
No.
Friday.
It's convenient for us.
Friday or Monday.
Monday, 20th. List on 20th March.
Number 13,
Peremptory.
Have you complied? No. Of the reasons assigned in the application. Duly supported by an affidavit order dated 17/1/2023 is recalled. 2 weeks time is granted. Except for service of notice on respondent number 2B and 5.
I am for the appellant in this case, my lord. In this case, my lord, on 9/1/2023, along with other connected matters listed, my lord, I have instructed to appear in this case and writ petition 75331/2013, my lord. And inadvertently, my name is shown in 49 bar writ appeal 49/2020. I undertake to file wakalat in this writ appeal and another writ petition.
You are Mr. Ajay Jain.
No, my lord, I am not Ajay J, my lord. I am appearing for Rajesh Shettigar. Ajay J, who is given the NOC, my lord.
So then nobody appeared.
No, last date of hearing along with the connected matter, it appeared, my lord. I have appeared and I undertaken to file wakalat on in this writ petition along with the writ petition 75331 of 2013, my lord. But my name was wrongly shown in writ appeal number 49/2020.
Application. Please support by an affidavit. Order dated 9th of January 23, recall W8781/2019 is restored to police. Please allow.
Maybe called along with that writ appeal 49/2020, my lord.
So again, you are planning not to appear, right? Again, we will discuss it. Again,
No,
file
my
an
lord. Last date of
application.
hearing, I am appeared, my lord. No, my
Don't
lord. Last date of
appear.
hearing, I am appeared, my lord.
We'll go on, mister. We will dismiss it if you don't appear. Again, file an application for recall. It will go on. Don't worry. Why should you worry? Yes.
15.
I appear for the appellant in this case.
What happened?
Delays in communications. So letters to the president as well as the authority. I think making false allegations against him. In fact, the letter to the President of India, there is allegations against the Senate single judge also, saying that he blindly believes banks. All these, I have produced bunch of emails, to one case. This, what the direction is sending this.
Yes, what do you say?
My lords, in this, my lords, the.
No.
Yes,
Just
ma'am.
1 minute. 1 minute.
Yes,
With this issue is pending adjudication before the High Court, correct?
yes, ma'am.
You are contesting it. Thereafter, it is decided by this court and whatever whoever either bank go or you go to Supreme Court, we don't know. Thereafter, you take recourse to all President of India and all that, right?
Yes, ma'am. I have in fact, I have advised the appellant also.
You undertake not to send any this thing email.
I have advised him, my lords.
Advise, no, correctly advised, right?
Yes, ma'am.
So shall we say that you undertake?
Yes, my lords. Your lordship may say.
All right. Hold on, IA number 1 of 2023. Learned counsel for the appellant. Learned counsel for the appellant submits that he has advised the appellant not to send any further emails during the pendency of the writ appeal. It is further stated that the appellant undertakes not to send any email with regard to subject matter of this appeal.
Yes.
During the pendency of this appeal before this court. Paragraph. In view of a court's submission, IA 1 of 23 is this.
Much.
My lords, in this, I'm for the respondent number 6, my lords. I filed an application for early.
Appeal is not admitted.
Huh?
I'm for respondent number 6, my lords. I filed an application for early.
Not important, right? What is important? No, what is important? Memo of retirement. No, tell us. Should we not pass some constructive order in the appeal or memo is accepted, permitted to retire and then proceed? Then somebody else will file an application for recall saying that I had filed, like just previous case you heard, item 14, he said that somebody else had retired and I did not appear because it was. What's important? Memo for retirement. 16 point. Huh? 16.1 and 16.2. When the case was called out, before learned counsel for the appellant could say anything, learned counsel for Mr. Nikhil. Oh, I thought persons by name Nikhil are good. You are good, of course. Mr. Counsel, Mr. Nikhil, learned counsel for R6. 16.1. We are not in a hurry, right? This is important. Okay. Which case you retire? We can take care of Mr. Patil's case later on. But first, this issue is required to be dealt with all seriously. So you tell us 16.1, which respondent? 6. Learned counsel for respondent number 6 submitted that he has filed memo for retirement and has given NOC wakalat. In view of a court's submission, memo is accepted. Office is directed to delete the name of Mr. Nikhil. Mrs. Bhavna GK, counsel for, it says respondent number 1. Bhavna GK is for 1.
16.1, please check.
16.1
we are asking. You are saying respondent number 6. You are not sure.
Show him.
First,
So we are here to facilitate. We will take care of your case later on, right? First, his issue is very important. What? What is it? 16.1 R1. Now, one by one, we are not in hurry, right? We are giving priority to your submission and keeping Mr. Patil waiting, who has filed the appeal. Huh? So, don't this. So, instead of respondent number 6, type respondent number 1. Committed to and is withdraw and whatever delete. Then what 16 point? 16 and 16.1. 16 also you write before case could be called at the out when the case is called Mr. So and so. No apology. You are giving priority to your case, your issue of retirement, which is most important. Respondent number 6. It is not listed for otherwise for memo, etc. Not listed, right? So respondent number 6 and then same submission. Delete the name of. You can relax now. Yes. Mr. Patil. Yes. What happened? Yes.
So this said also it is listed from early hearing.
Well,
That's fine.
my lords, I have filed early hearing, my lords, application for early hearing. Respond number
Yes.
6.
Yes.
My lords, it's an acquisition notification which was set aside because it was initiated.
Item 16.
Item 16, my lords.
Of course. So you are appearing for which respondent?
Respond number 6, my lords.
Acha, we just now sought a retirement. You
Yes.
are appearing.
Is filed analysis.
Yeah.
I'm an NOC, my lords.
Okay. Yes, what early hearing?
My lords, this is a respect to the acquisition proceeding which was set aside.
Appeal has not been admitted as yet.
Appeal has not been admitted, my lords.
So then what early hearing? You want orders on admission? We can list it. You argue on admission whenever. Heard on IA 1 of 2023. Yes. You also filed a memo of retirement. You are appearing for?
For state, it is already filed.
Just a minute. Which case? So what's your name? 16.1 and 16.2. Learned Counsel. Mr. So and so, Learned Counsel submits that copy of memo of appeal. You appear for whom? No, which response? Learned Counsel for state submits that the copy of memo of appeal has not been served on him. In view of aforesaid submission, Learned Counsel for the appellant undertakes to supply a copy of memo of appeal to Mr. So and so. When? Then you have to supply. We don't. Any convenient means it should be convenient for you. Within how much time will you supply? That's what you are asking. Within 1 week. Let IA 1 of 23 be listed for consideration thereafter.
My lords have to fix a date, my lords.
After 1 week, you just now you have heard, right?
Right.
After 1 week, please.
Right, my lords.
In case it is not listed, move a memo.
Grateful, my lords.
Section 8. And guardians act. And sought for sale permission the property, the education of the petitioner. And because it's difficult to maintain the property and no other income. That was rejected. Respond.
Heard on IA number 1 of 23. No orders are required to be passed on IA 1 of 23 as the appeal is within limitation. The same is accordingly disposed of. But on the question of admission as well, appeal is admitted for hearing. Issue notice office. Is admitted for hearing. Office is directed to
Admission, you are 18. With the exam income, educator, government educate,
Right. You ready, mister? Huh? You. Huh? Okay. All right, when? No, whatever you say, both of us, you tell he is a party in person, we have to ascertain his convenience. 24th. We know that. Your appearance, ensures that. Outer limit for you is 20 minutes. Learned senior counsel with Srimati HR. Mr. N. Shekhar, learned counsel for respond number 2. Party in person. This on 24th March 23. March 23. Whatever we'll hear him, no? We will hear both the parties on 24th. You ready? Be ready. Which is your speech? Don't time. Give it to him better. Yes.
19, Narayan Swami Priya, and order, 1 of 7 days and 21 cents. Big payment. 1 of 7 days and 21 cents.
Current counsel for appellant submit that respondent number 7 has died on 21/10/2022. He therefore prays for and is granted a week's time to enable him to make an application seeking substitution of LRs of deceased respondent number 7.
20, 23 offer.
Yes.
But this appeal note was heard and admitted. Before level to
Has been admitted, right? The appeal has already been admitted for hearing. Oh. Right. So we will say formally, the appeal is admitted. Fine.
The order of execution order is dated 9/4/2019. And the writ appeal is filed on 18/8/2021. There's a delay of 742 days in filing.
311.
19 April, the order is passed.
No, you are supposed to argue on admission also. Are you ready? It is listed for admission, madam. What do you say? We will condone the delay, hear them on it.
effectively participated in the deliberation. Effectively participated before the learned religion. It also not for middle part.
Okay, don't record.
Is this matter?
On again, also there is no open.
That's a different thing. That we will decide. Yes, madam.
The applicants are all able persons.
No, that doesn't mean that they are above law. The law applies to them. Then you have to make out, supposing if we hear you, what is the sufficient cost? Old persons, that means how old? What after what age does not, law does not apply? You'll have to tell all of this to us. And by from what age law does not apply? Huh? That they are exempted from doing the requirement of sufficient cause for condonation delay from which age? 60, 58, 65, 70, 75, 80. What? That, which Supreme Court decision says that it is so that if you are above 65, then you are not required to show sufficient cause? Then file an application, madam. File better affidavit. And it counsel for the appellant praise for is granted. How much time? 2 weeks time to enable her to file her affidavit of application for condonation.
I am for the appellate, my lord. It's a counterclaim for restoration of conjugal right was decreed. My petition for divorce was dismissed. Connected appeal was admitted by your lordship, my lord. In MAP number
It is
13
admitted list for analogous hearing along with MFA number
1374 of 22, my lord.
1374 of
2022.
2020.
Yes, please.
Number 23, priority and
Application order. Application order 711 also. Now it's
Yes, madam. For the appellant has filed a memo seeking deletion of name of respondent number 3 from the cause title on the ground that her other legal representatives are already on record. The aforesaid memo is taken on record. Let necessary amendment be carried out in the cause title list in the next week. Why? You are not, except 20th, you are not there anytime, 4 days. You have to, madam, you have to give precedence to the High Court, not to the trial. Perhaps what we believe that if your matter is listed before Supreme Court, you cannot seek adjournment on the ground that I have trial before the hierarchy of things. Hierarchy of things. I mean, you have to respect us, even though you don't want. No, you don't want. You have to respect. We have to respect also this chair so long as I'm sitting. I can't do anything which I feel like. So don't, that is no ground. According to us, we don't want to write that you have made a prayer for 20th on the ground that you are busy before trial court and therefore we reject. We don't want to say that in the order. Orally, therefore, with this thing, with all humility at our command, we are telling you that it's not possible. If you can't appear, we will see what can be done.
Shri Abhishek Malipati, government advocate.
Current senior counsel for the appellant petitioner submits that the rejoinder shall be filed during the course of the day. And a copy thereof shall be supplied to learned counsel for respondents. List on 20th March 23.
25, Shri Giridhar.
Section 10 petition for judicial separation dismissal.
It is admitted for hearing issue notice record.
Petition for under section 10 of Indian Divorce Act allowed. Caesar dismissal.
Appeal is admitted for the same on.
27, Shri Srikanth.
26 may not respond in my lord before the trial court is ex parte.
Admitted. We have admitted it. You file an application. We have said issue notice, file an application, we consider.
Right.
Yes. So what's yes. Huh?
Direction was given not to redo
No. Which was the first petition?
not spend.
In which you are the party. You had filed a petition. Huh?
I had filed
No, first one. There are several rounds of litigation. We are asking.
not system to not page number 30 alerts.
Huh? Let us which petition?
WP 529 of 2023. First file
2P
529 of 2023.
Ah.
So
23. This was the first petition.
No, first petition.
We are asking for chronological sequence. That's what you, instead of describing it in a simple way, you have filed a bunch of documents. Yeah, simple, right? One petition, this relief, what happened? Whether you went to Supreme Court, second petition, what happened? Third petition, what happened?
So it's filed before the court. No, that is.
Page number 12.
So which first petition, which petition?
Page number.
Chronological sequence, Mr. Simple. How many petitions? How many petitions have you filed, or you have been a respondent in the petition? We want to know. Because repeatedly it's coming up before us. That's why we remember. 95. But you did not file it in convenience compilation. Range, Mr. Srikant. Range.
Page 95. Right. WP 25780.
First sheet, yes, ma'am. This is the first. 257.
WP 25780 of 2020. Page 97.
But you are a petitioner in WP 25780.
780 of 2020. Petition notes.
What was the prayer in that petition?
The short form notes, redoing of the notes as according to the repetition which was allowed.
All right. To consider candidature of the petitioner while redoing, right? Huh? Consider.
It was allowed.
Just a minute. 1 minute. You had withdrawn this petition. Third, just a minute, 3rd of January 23. Withdrawn and liberty granted to file a fresh petition in case.
Considered by people was made. As such, not I required one more petition.
Ah.
Page number 30. Please.
Petition.
WP 529 of 2023.
WP 529. What happened to this? What is the, what was the prayer?
It is extracted in your spending from the patient.
Declare on consideration of the case redo. Dismissed on 10th of January. What happened?
I approached the only Supreme Court was sorted.
What happened to SLP?
Simply as business, it's an observation. But needless to state that the petition is otherwise entitled in the rest. In accordance with our order dated 16/2020, passed in SLP court 2023 extra, etc. Therefore, the is not dependent only on the person, whose petition was made before the honorable court and was dismissed the ground of delay. So it's we filed a review petition on civil actions. Against that,
Who filed the petition?
the petitioner also filed a petition. That person also filed a petition.
No, who is that person? That's what we are saying.
Anush showed up was the petitioner.
No. So your SLP has been dismissed on 10th, right? With this observation, right? So now what you, now thereafter you have filed this petition. Why?
Because
If they, if they don't consider,
what happened?
no, just a minute. We understand. Your case is that in accordance with the directions issued by Supreme Court, just a minute. Then we will hear you. We are just trying to, this is what we are understanding, right? Unfortunately, our understanding is important. We will hear you. So what we have got is that as per directions of the Supreme Court on 10th of February 2023, your case has not been considered. So contempt.
It's not assessed.
Huh? No. So you are now, what you are saying is that in accordance with the directions issued, are we correct in understanding this? That your case has not been considered in accordance with the directions of the Supreme Court on 10th of February 23. Therefore, you have filed this petition seeking a direction that they should admit you in accordance with directions of Supreme Court on 10th of February 23.
Now they have
Correct. Correct.
But what happened was now they have issued endorsement to me saying that see, your NEET ranking is less compared to the one who is admitted earlier, and as such we cannot consider your request.
So it has not been rejected on the ground of delay.
Not on the ground of that's the reason.
Therefore, so you can't say that there is a violation of order of Supreme Court.
It's a violation.
Then contempt this. We will please, I mean, this is a double-edged weapon. If you are arguing that it is violation of order, we will relegate you to Supreme Court saying that contempt, file contempt. Please think about it. What's your case? That's why we are asking you. If you are saying that your case has not been considered in violation of the directions, we will say that your remedy is contempt, not a fresh writ petition. We have already adjudicated your claim.
The case is just.
We don't time and again we can't consider Mr. Srikanth. Please appreciate. So what is now? What do you say now? In violation of directions of Supreme Court, your case has not been considered, right?
The directions which were
Not considered in accordance with. Not considered in accordance with directions of Honorable Supreme Court. What has which endorsement is there?
that is included in this
H1.
Lordships kindly come to my lords, the annex. That is my lords annex red. What is it? They record notes, the observations given in the Supreme Court, second paragraph. Then they refer notes the neat rank of Sri Session, not the petitioner, is 8,24,288, while the neat rank of Satvik Shivananda is 52,488. And my lords, they refer to the petitioner notes in another. What they include, my lords, is that page number 125. Aditi Dinesh Rao and Anush Gowda.
What's your name? What's your name? For Anush Gowda.
Sri Session.
It is not there.
It should be saying that those who were elected by the Honorable Supreme Court, they were being accommodated. But as far as my case is concerned, my neat ranking is low. As such, I will not kindly see the last paragraph.
They are referred everything.
Please
Comes
read- please
Full
read
reading,
it.
please read this full entire endorsements. From the first line.
SLP number 454 of 2023. Connected with SLP civil number 4 of 2023. The Honorable Supreme Court with order dated 16/1/2023 has held as below. Insofar as grievance of the K. Vishwanath, Government Senior Council appearing for petition in SLP number 914 of 2023 is concerned. The impugned order cannot be construed to be adversely affected the rate of the petition if the petitioner is otherwise entitled to in the general meeting. Sri Srikanth has submitted the application number A 13/2/2023, received the A on 14/2/2023. Saying that her case should also be considered as directed by the Honorable Supreme Court in SLP number 2432 of 20. The said order dated 10/2/2023 states as needless to state that the petition is otherwise entitled in minutes in accordance with our order dated 16/1/2023, passed in SLP number 454 of 2023, etc. The claim of the petition should not be denied only on the ground of delay. The neat rank of Sri Srikanth is 8,24,280. While the neat rank of Satvik Shivananda is 6,498. The petitioner Aditi Dinesh Rao is the 2,465. Their seat allotment status is as follows. Then they give notes ranking difference as P4, and they give the notes first option where it was here. Seat ranking.
You also. Anush Gowda's in this case to be considered if he's in. Anush Gowda's ranking is 3 lakh 20. His ranking is 8 lakh 20.
The petitioner Anush Gowda recently 2495 AP zone. Their seat allotment that is so they can say before and allotment. Aditi Dinesh Rao and Anush Gowda have already been allotted seats as per the order of the Honorable Court in the Supreme Court order. Pranita SR and Kushi in Mumbai, who are allotted seats have been cancelled to re-allot Aditi Dinesh Rao and Anush Gowda. The cutoff rank of Jawaharlal Nehru Medical College, Belgaum, where Satvik Shivananda has been allotted seat under GM is 81,439. Since neat ranking of Satvik Shivananda is 62,488, which is much higher than the cutoff of that college, it is evident that even without sports quota, he would have a secured seat in the sixth college of the GM category. In pursuance of the Honorable Supreme Court in the second of 2050, his seat cannot be disturbed for sports quota reservation. Claim of Sri Srikanth cannot be considered for this seat as her neat ranking is 8,20,288. So it will be observation.
What is the last date? What was the last date for admission to MBBS course? Wow, what is what? We are asking you. If you don't know, then we will ask you. What is the last? What was the last date? Call Mr. Ramesh. Mr. Ramesh.
Date. 8th January.
30th January 23. Last date. All right.
Actions of
No, Mr. There are two things, Mr. Srikanth. We should be fair to you, and therefore we are telling you two things. You can still withdraw this petition, approach the Supreme Court for contempt, or if you ask us to adjudicate on the validity of endorsement, we will do so. Right?
Keeping
Option
in
is
mind,
yours.
keeping in mind the last date.
Ah.
We can extend that.
All right. No, It's not like this that you argue the case. Then when the court tells, then you will seek an opinion from someone and we would have, no, you are arguing this. It's not fair, right? Please, you have commenced the argument. We only wanted to be fair to you because you said if we will adjudicate the validity of endorsement in this writ petition. And in case it is your case that there is a violation of the order passed by Supreme Court, then file a contempt petition. Otherwise, endorsement, we will decide whether or not they have rightly passed and whether your claim has been rightly rejected or not. With this, we will decide. Yeah, we don't know. Don't take it. Not fair, Mr. Srikanth. You agree? You agree that after arguing, after having come to know the mind of the court, why? I mean, you are Mr. Srikanth, you are otherwise a fair counsel. Why should you do like this? For this thing, you are not getting admission in MBBS course. You don't want to become a doctor, nor do we want, right? We have lived our lives. Shouldn't do it for a case. Your reputation as a counsel is much more important than this case, right? Still, we will adjourn you. But we will record this, Mr. Srikanth, after arguing the matter to considerable length and after ascertaining the tentative views of this court, prays for adjournment. After arguing the matter to some extent, prays for adjournment. Just on. Don't do it again. I don't like it. Don't. Please. No. You should, in the beginning, you should have sought for an adjournment. We would have happily granted. We don't adjourn. We are granting adjournment nowadays. We don't. We have lost that zeal of deciding. Why should it's not our case? I am not getting admission in MBBS. Why should I run after? Right. So that's why we have lost. You should please do it. And at least follow this basic etiquette in my court that if you want an adjournment, say in the beginning. Don't after arguing, after it gives a very bad impression to the court. We are adjourning it, but doesn't based on which date? Now your date of your choice. Whatever date you choose. Praise for adjournment based on 20th. Please do not seek an adjournment on that.
He also said that.
No, this it can't disturb. We are hearing you on admission. Nobody else can argue until this notice is issued. No, please don't time. This is not fair, Mr. Srikanth. And we are telling you, we are telling you in advance today that you have to argue this case on admission. Nobody can else support you by saying that grant him admission. Don't for this set up your people there. No, this is not fair. This perhaps, Mr. Srikanth, you should remember this is not the only case in which you are appearing. Thereafter also you will appear. Please. How can Mr. KT argue? No, how can he argue? We are asking you. No, please. We are asking you. The matter is yet to be admitted. You have been last date of hearing also. You did not disclose. Then we asked you give the details of the petition filed by you. Then you filed a convenience compilation. Your junior sought an adjournment. We gave an adjournment. Thereafter, you have argued the matter for about 10 minutes. Then you are seeking an adjournment. Then you are saying, we are asking you what date. Then you are saying the date of Mr. Keti's convenience. Where does Mr. Keti? No. Where does Mr. Keti come into picture? We want to know.
Two issues.
No. How can we want to, Mr. You are practicing this for a pretty long time. Please point out from the rules of the High Court that if a counsel for petitioner is in difficulty, somebody else will appear and will support him. No, this is it. So you said Mr. Keti will argue where he doesn't figure in. We have not said anything. We are hearing you on admission, Mr. How come Mr. Keti addressed this? Under which? Please tell me the rule. We would be happy to hear him. Rule. Which rule? 20. He can't appear. You will have to argue. Tell us on this ground, his endorsement is bad. We will If we convince, we will issue notice, then he can ask you, he can support you. We have got it that he is supporting you, but before that, before supporting you, see, admission of a case or admission to MBBS course is not dependent on his submission, on his supporting you. It is dependent on our order. That you are forgetting.
Two legal issues.
No, he can't canvass.
I understand.
He will canvass only when notice is issued. No, I mean, can he appear? I mean, we want to know from you, really, frankly speaking. I want to know which provision of High Court rules and orders. Where does it say that in case you have no. Notice is not order. How can counsel for respondent claim right of audience? Which provision? Tell us.
It's not that, that's the reason I said not shall go on with the submission.
Nothing happens. Don't, Mr. Shrikant, don't do this.
No, I'll go ahead with these.
No, and he doesn't have a right of audience. You will have to show us under which, please bring that case law also. Which shall we record that you will bring under which provision counsel for respondent is entitled. That's nobody else can, you will have to address the court on admission. Well, after we are satisfied, then we will issue notice, then anybody else can appear. It is not. Want to argue again? Oh. Please. Please give. Yes, please show us which is the requirement for recruitment. Please show us from this. Which page? Page bylaws and what rule and this thing. Just for. Yes. Oh, that what are this thing is governed by which provision of the bylaw and what rules that which page? petition. This is WA. 6739 or 49. 6739.
Yes.
Yes. This is 19 is 109 is writ petition. Bylaws and which rule? Header and recruitment rule. Basically, Mr. We want the criteria for selection. What is the criteria for selection? Which bylaw and which rule provide for criteria of selection? That's it. Huh? This constitution of selection committee, right?
Yes.
And what is the criteria for selection? Ah. Header and we will put you straight questions when we expect straight answers from him also to narrow down the controversy. Right? The contention tentatively subject to hearing views that his contention appears to be correct, that he was eligible for to participate in the process because the preference, the 10 years experience is only a preference, it is not an essential qualification. So he may not have been selected, that's a different thing. But he was entitled to participate in the process of selection because the basic eligibility criteria is BDS degree, correct? So now, second is the problem in his way that having appeared in the before the selection committee, he cannot turn around. We will ask him that question. He cannot turn around and say all this now, which is contending, right? So he has locus to maintain the petition. At his instance, it could have been questioned, but you are supported by Supreme Court judgment saying that after having participated, he cannot turn around and challenge. That is your main ground, right? Yes, Mr. Tell us, how could you have challenged the process of selection after having participated? All other contentions, you are eligible to participate. We accept your submission that the basic requirement was BDS, right? And therefore, and the preference of like 10 years experience was only preference. So therefore, you are entitled to appear. You had the locus to file the petition. But how these questions, that constitution of committee and all this, we will tell you the reason. Why? Because what has been done is that you have appeared when when have you appeared before the interview selection committee? 18/10/2016, right? On that day, you knew that the selection committee is not in accordance. What did you do?
The interview was scheduled.
The interview was held on 18th.
28/11/2016.
You are waiting for the tentative select list to be issued. When your provisional select list, your name did not appear, you came up with all the objections. That is what is called fence sitting.
understand.
Fence sitting. That is what is called fence sitting. That is what is against you. So you did not, we would have understood that if you appeared on 18/10/2016, if within 2 days, 3 days, 1 week, you should have immediately come up. No, this all fraught with illegalities. Constitution is not proper. This is malaf ID. All this we would have understood. But you waited for the tentative select list to be issued, and thereafter you have filed the objection on which date, you tell us.
I filed the objection. 9/12/2016.
That's the problem.
Prior to the objections filed for by the 12/12/2016.
But you had waited, supposing, Mr. Please tell us, supposing if you would have, your name would have appeared in the tentative select list, would have challenged it saying, no, this is all bad? Because for that very reason, as a matter of principle, you did not seek the relief. But would you have raised an objection? Obviously, no. Why did you file? This is what is called fence sitting. Wait, give it. You had given us one of our judgments. Where is it? Please? Right, Mr. That's the answer. Fine. Yes.
This bylaw LC provide for objection. I was not aware of that. Therefore, my lord,
Not aware about the bylaw.
once I got the copy of the bylaw, my lord, then I made my. That is
Have you said anywhere on this day?
my objection. My objections are
Writ petition, is it the ground? Writ petition. Fine. Huh? All right. All right. Fine. Yes. All right. Para, yes.
Para.
Give it to me. We know, right? That we are taking, you are telling us. We are putting a query to him on this, and you are telling us same thing, right? We have told it frankly. Because we want to dictate every order now in the presence of the council. So we are dictating. That's the demand of the bar. Every order should be dictated in the presence. We are dictating it. Sit down, relax. That's why we have to ask him openly. Yes. Para 11. Yes, madam. Right. Learned counsel for respondents. Yes. Yes, Mr. 6, 7. You have succeeded before learned single. You are sailing with the same. Yes. What? So he has argued. What? 5/12/2016. All right.
My submission is that the is not happening. You have to work on that. Unless
They are that 40 years of age, above 40 years. That he has argued. Yes. So, para 11, learned counsel for respondents stroke writ petitioners, while inviting the attention of this court to the notification have submitted that there is no requirement of experience of 10 years and the same is a preferred qualification. It is pointed out that the basic qualification required for the post is a BDS degree, which the writ petitioners possess, and therefore the petitioners are writ petitioners were eligible for consideration. Full stop. It is also contended that selection committee which conducted the interview on 18/10/2016 was constituted in contravention of bylaw number 12C of the bylaws of the institute, and both the selected candidates are above 40 years of age and there is no relaxation. There is no relaxation with regard to their age. Full stop. It is also submitted that out of the 3 candidates, you said two of them were not qualified, 3 of them select committee. 2 of they were not qualified. It is also contended that out of the 5 members who signed the proceedings of the committee, 2 of them were ineligible. Therefore, no sanctity can be attached. Therefore, no sanctity can be attached to the proceeding or to the recommendation of the select committee. It is submitted that paragraph. It is also pointed out that on publication of the provisional list, the writ petitioners had submitted objections on 5/12/2016 as well as on 9/12/2016. However, it is fairly admitted that appellant in WP number 6449/2017 did not get the benefit of relaxation in age, as at the relevant time he was 35 years of age. It is contended that order passed by the learned single judge does not call for any interference. Paragraph. We have considered the submissions made on both sides and have perused the record. Full stop. For appointment in respect of full stop. The bylaws of bylaw 12C of the bylaws of the institute provides for constitution of the selection committee. Bylaw 12C is extracted for the facility of reference. Then the criteria for selection on the post of assistant surgeon BDS is provided in the cadre and recruitment of the institute. The relevant extract of the recruitment rules reads as under. Right. Yellow flag. Thus, line below. Thus, a candidate was required to be a holder of degree of BDS of any university, and the preference was required to be given to those candidates who have worked with various health camps in an oncology-based institute. Full stop. The rules further provide that a candidate who has experience of work experience of 10 years in oncology institute may be preferred. Paragraph. Before proceeding further, we may advert to the contention made on behalf of we may advert to the contention made by learned senior counsel for learned senior counsel as well as learned counsel for the appellants that the writ petitioners had no locus to file the writ petition as they were not qualified for consideration for selection to the post in question. Full stop. from perusal of the requirement laid down in the rules, it is evident that laid down in the cadre and recruitment rules, it is evident that the basic qualification which was prescribed was of a degree in BDS, full stop. The requirement of having 10 years experience, no, full stop. In the aforesaid rule further provides, the rule further provides that the candidates who have work experience of 10 years in oncology institute or of having attended various health camps in an oncology based institute shall be entitled to preference, full stop. Entitled to preference, full stop. Thus, the requirement prescribing the experience was not a basic qualification. Therefore, the contention of the appellants that the writ petitioners were not eligible for consideration for appointment to the post of Assistant Surgeon BDS does not deserve acceptance. Accordingly, the same is repelled. Paragraph. In the judgment, Mr. You gave us single bench. Why this thing? Single bench you gave. See, first we kept here. Sorry. We have got paragraph. Now we may advert to the core issue involved in these appeals, namely whether it was open for the writ petitioners who had participated in the process of selection to turn around and to challenge the process of selection. Full stop. Before full stop, we may advert to full stop. The Honorable Supreme Court. So and so, right? Para 7. Across Institute of Fluent and Education. Which is the judgment? Similar view, like this para 7 you take up to here, Uttar Pradesh, right? Similar view has been taken by Honorable Supreme Court in Dr. Saroja Kumari versus R. Helen so and so, Hila Form and others. AIR 2017 Supreme Court 4582 paragraph. In the backdrop of aforesaid well-settled legal principles, we may advert to the facts of the case in hand. This is the citation. Advert to the facts of the case in hand. Full stop. In the instant case, admittedly, the writ petitioners as well as other candidates appeared in an interview held on 18/10/2016. Full stop. Thereafter, the tentative tentative select list. Thereafter, the provisional select list was published on 28/11/2016. Full stop. It is pertinent to mention here that the writ petitioners maintained stoic silence between the date of interview till the publication of tentative select list. Only on publication of tentative select list, having found that their name does not figure in the tentative select list, the writ petitioners filed objections on 5/12/2016 on 9 and as well as on 9/12/2016, which were dealt with by the institute and were rejected on 8 and were rejected on so and so. Full stop. rejected on that. You have shown us when, Mr. Eh, huh? All right, and have been rejected by the annexure, at least wide annexure R, right? Paragraph. The annexure R, full stop. Thus, from the above narration of facts, it is evident that the writ petitioners had participated in the process of selection without any demur and without preferring any objection till the publication of the tentative select list, whatever list. Provisional select list, full stop. The full stop, full stop from the conduct of, from the aforesaid conduct of the writ petitioners, it can safely be gathered that they were fence sitters and were waiting for the outcome, for the outcome of the process of selection, full stop. The writ petitioners having participated in the process of selection uh, cannot be permitted to turn around and challenge the process of selection at this point of time. Full stop. Even otherwise, their conduct disentitles them to any discretionary relief in the exercise of extraordinary jurisdiction under Article 226, extraordinary discretionary jurisdiction, or under Article 226 of the Constitution of India, paragraph. In view of our aforesaid conclusion, conclusion, paragraph, for the paragraph, in view of our conclusion that it was not open for the writ petitioners to turn around, writ petitioners who had participated in the process of selection, without any demur, to turn around and to challenge the same, it is not necessary for us to advert to the question whether or not the selection committee was properly constituted, full stop. It is this, you have not taken this thing, the pleading with regard to double adoption or double yardstick, etc. No pleading. As far as the finding recorded by learned single judge with regard to adoption of double standards of yardsticks for assessment of the assessment of assistant surgeon MBBS and assistant surgeon BDS is concerned, suffice it to say that no such pleading was taken no such pleading was made by the writ petitioners in the petition, full stop. It is also right law that a plea of malafide required to be pleaded into. The writ petitioners, they had not pleaded the malafides and had not pleaded any of the officials of the institute as responded. Therefore, the finding that the director that the director malafide altered the criteria to favor the selected candidates could also not have been recorded in the absence of any pleading, full stop. The full stop, the issue of relaxation in age also fails into insignificance. Paragraph. For the aforementioned reasons, order dated 20th September 2017, passed in WP number 12907 bar 2017 and in WP number 13427 bar 2017 is hereby set aside. In the result, appeals are allowed. Same. That is by law.
Eligibility.
Eligibility criteria you have.
To extract that. Flag number 2, you have put.
In bylaws you have.
He could not send home, sir. That's, that I read. That is right. I'm asking whether he has come from. Oh. It's not right. Let's see. I'll-
Secretary, executive record, 8 minutes.
Yes, yes, Mr. Yes.
Still, there's a point. This aspect, absence of. Page 23, the family court answers. So I D, mirror will engage. And fourth mirror. The last, and we see the reasons. Nine. Six. The way fast, very different. Reason is. Okay, okay. Please. System. What is important for the that entire and the wife did not challenge. And therefore she accepted the see that
What happened to that key complaint? Yeah, we just asked her, said you complaint should be asked what happened. It ended in equity. But you should tell us what is the pleading of cruelty, what is the evidence, what is the finding. Then we will. So first of all, what is the pleading of cruelty?
After the marriage, traditional respondent had their happy marriage, marital life at the house of the petitioner and so and so village Chikmagalur Road. The petitioner was working at Indian Army, joined the army after 25 days of his marriage, leaving the respondent in the safe custody of his parents at a nursing home. When the respondent was with the parents of the petitioner, she started talking through mobile phone for hours together. The same was noticed by the parents of the prisoner. The parents of the prisoner were under the impression that the probably respondent might have been talking to prisoner, but whenever the prisoner used to call to the number of the respondent, we used to get the recorded answer. The number to which you have dialed is presently busy. Please talk to some time. Further, in the month of June 2011, respondent had left the house of parents of the prisoner to write the MA exams, but has not attended the exam. They had gone with Ashok, who is her maternal son. Further, the prisoner's parents have requested the respondent not to do such acts and warned the respondent to do the acts. In this regard, prisoner made serious queries why a respondent is doing all these things. Then the respondent disclosed that after her marriage with the prisoner, he had an affair with Ashok, and he was 6 months younger to her. Marriage was not solemnized by her parents, and she got married to the prisoner with the intention to get the job easily. 4/9/2011, the parents of the respondent were informed regarding the same. Parents of the respondent requested the prisoner and his parents not to disclose of anything. On 6/9/2011, nearly 20 to 30 members of the respondent family came to the house of the prisoner, started doing the latter. Parents of the prisoner narrated all the facts. Then their relatives left the place answerlessly. On 9/9/2011, prisoner got into the legal notice. Calling upon the respondent narrating all the upset facts, demanding to get separate. Respondent replied to her advocate on 26/10/2011, making false allegation. On 17/1/2012, the respondent lodged false complaint, police against the prisoner, his family members, alleging the story of rowdy demand, making false allegation, which has been numbered as human claim number 12 of 2012, by the Court of Karnataka. Thereafter, petitioner and his parents was approved. The petitioner waited all these days. At this level was to solve the dispute. It yielded no fruitful way. Therefore, according to him, he wanted to resolve the dispute. So, therefore, he has condoned. The state that there is some overtax on the part of the he will not condone it. Then parallel, when he beyond the intolerable mental torture, harassment created in the petitioner had decided to do. So therefore, the allegation is that he had filed it. That is the one allegation. Another allegation is that he got the two ground. The respondent has denied these relations. Yeah. Good. I told the repeating paragraphs is denied the evidence. Her case is stated. The parents of the petitioner and the respondent are known to each other for decades. Father of the petitioner is high school teacher. When the marriage was initiated with the father of the petitioner, according to this demand, the marriage was celebrated. They do in a well-built school village, spending more than 2 lakhs. But giving demanded golden and silver ornaments. Petitioner told. The during stay of the respondent to petition. The petitioners were very happy with the respondent. Unfortunately, the power of the petitioner was required. The petition regarding the personal discussion. He was requiring the experience of petitioner with the respondent. Going for activities between the petitioner and the respondent. That the petitioner father is a dictating the petitioner. The petitioner needs to be very obedient. He was acting according to the dream of his father. All of the petitioner is a sadist and simple accusation. He was doubting every activity of the respondent, which was decided with the parents of the petitioner. But the petitioner father, for the reasons pursuant to him instigating the petitioner, the other family members do 50 government work to finish the respondent and reach to discourage the economy. During the stay in the house of the petitioner. The petitioner had promised the respondent that he would take the respondent to the workplace, which is at a distant place, as early as possible. But the respondent, being a beautiful Hindu wife, was dreaming the present life of the petitioner, in spite of injuries and undergone by that, hands of the parents of the petitioner. On one day, the petitioner was driven out the respondent. Respondent is a real weird and good person. The beard of the petitioner. Spite of all these mediations, stand by her. Very much intended to lead the good and happy life. But because of the demotivated mind of the you are not being allowed to be the Krishna. Therefore, the allegations made by you. And the husband has testified himself as PW1, and he reiterated what is alleged. And the respondent being there is a vote against. Similarly, the wife.
Any child born out of marriage.
He did not take her account to his workplace. He said she was left in the safe custody of his parents. He never taken. You watch the kindness of the legal notice because it is within 6 months of the marriage. The marriage was on 13/3/2011, and legal notice was issued. Legal notice 9. 6 months there after the marriage. And of course, the wife replied, the very question of causing guilt is not. And desertion also. Desertion to succeed, the petition for divorce under desertion. There shall be a qualification for a period of 2 years. That is not there. The governor there has not in lots of fantasy has not appreciated considered without the evidence at all. Yeah, page 23. Page 23. He refers to only to the ethical, the out of ethical recorded figures. We did para 13. That is the only para we have discussed the evidence and held that the husband is entitled for para 13 at the running page 25 and page 11. In this regard, it is pertinent to look into the deposition of Article 1 to the uniform of page number 3 of the the Procedural at page number 2, she had admitted that she had applied for MA exam through correspondence course. Further, she has also admitted that she never attended this exam. Further, she has also admitted that she had gone to training in the pretext of submitting application to secure a job in one of these schools. Each admissions of other than one to uniform corroborates the claim of the petitioner that the respondent had applied for MA. In that prospect, she had left the house on pretext of attending the MA exam, but she did not attend the exam. Further, she has not specifically disputed one Ashok is her son, though she has denied him any immediately according to the petitioner is working in Indian Army. It is away from such being the case, it is estimated that the respondent has filed the FIR for the rural police against the petitioner. His parents, 17-1, which is subsequent to the legal notice dated 9/9/2011, not issued by the petitioner to the respondent. Therefore, this act of the respondent, lodging the FIR, six of legal notice, it indicates that respondent has filed the above human case only as a matter of fact to overcome the contention of the legal notice. Furthermore, from the middle of the case, settlement copy of the petition, DC 219 dated 15/6/2003, to Local Constitutional it is to be seen that the Local whether you are arrayed as a functional under section 3 and 4 of Court of Karnataka. This acquittal of the JNFT based on association available of including the evidence who is the respondent. The nothing mentioned that rejected evidence as such in paper at the application level against the petition hearing. However, this statement has not placed any materials on so that she has started rejected. Therefore, the contention with which the has made false and against the on account of the same, he has suffered mental appears to be acceptable on account of the which has getting presumption mediation, and accept in money opinion. There are satisfactory. But he protects to grant this one. So my respect is sufficient. But he made an allegation, a serious allegation. Having made such an allegation, but he has given and yet also, though he did not answer, there was some active, but he says that these admissions of order corroborates the claim of the petitioner. That context, she had left the house, the text of attending, but she did not have. Further, she had disputed the fact when Ashok is her, it cast stigma on the and on the other hand, by making this allegation and having failed to prove it, it causes severity on the wife. It's not that the wife has severity, it is the husband who has severity. But the other judge says the allegations made by the wife that there is a demand for the receipt of baby, and also that she was muted out to 70 and all. Really, because wife has failed to do her defense, it doesn't mean that, it doesn't, it's so bad. Because the husband succeeding, like the weakness in my defense. Of course, wife makes certain allegations, he fails to do it. It doesn't mean that husband succeeds on that. The husband has to prove his allegation. So far as this adultery allegations are concerned. The revenue should be party, and in absence of that, the petition is not taken.
Yeah. 67.
Because she mental control. So because even like state that immediately he is ready to work. So far, relative of the husband also, even before marriage. Before marriage. Husband. Another judgment of student.
What para? You read what? Para 9.
Para 9.
Now, what does it say?
The allegation is that you because for the current. It's certain language. The Supreme Court said, merely because wife has received doesn't mean that we don't have a relationship between wife and the writer of the act. Is what we want. As per the rules of the required to required to be made as a party in such a procedure. So maybe I have read the allegation.
Para 11.
So it is not made a party, I have the, I was to. Therefore, not
What means there is no evidence, but the trial court granted the divorce taking into consideration after the receipt of the legal notice to file a complaint, and that ended in appeal. Line 13 in detail the court has discussed. He must leave with the apparent only for 45 days. And from there on, he was in duty, on his duty. Therefore, there is no occasion for him to demand the duty. Apparently, the trial court that comes to the cruelty. And that ground only trial court granted the nuclear rights. That caused for no intervention.
What is that? When you consider the margin,
You didn't think that your turn for rejoinder will come soon? Huh? Yes. All.
that's all.
Reserved. Mark it. Arguments heard reserved for judgment.
Same issues. Not evidence. You
31.
Notice it.
18? 18? First read the this thing, petition. What grounds they have pleaded?
Honest, the husband is the petitioner.
Which paragraph you are reading?
MC petition. The response. Couple whenever happy minds in life, you know, both sides need to be taught. It's a thing. So now, of the respondent that is the couple has given working and responsibility to the para number 3. So coming to the housing director, lady should ask, but the respondent has ever not taken care of the baby, needs to manage clarification of all efforts carried out of the petition of parents to bring back the harmony in the family is to be maintained. As a respondent is indulging in illicit living styles such as consuming alcohol, smoking cigarettes, and watching television, and also to consuming and force the petition to watch treatment, will be responding to the petition to bring the objection filed by the parents, the three states in aftermath. Accordingly, this respondent accepted for continuing or education by deciding the parents. For about 2 years, the petitioner stayed in his parents' house and for the respondent order to complete the initial education, the respondent incurred expenses which is money of 50,000. The respondent only with the intention to provide. After completion of LLC, the petitioner started to reside in the respondent. Once again, the respondent expressed the willingness to study BA. Accordingly, this respondent made arrangements to attend. Petitioner attended BA only for the period of 6 months. And in that period, respondent used to responsible for connecting with about 3 years. And also for other attendance by the money for period at the the maximum group and in regarding the mental bill. These the
challenge cross-examination. Has it been challenging cross-examination? Her statement that the attack.
It is not pleaded also, sir. Pleaded. She just filed a petition, saying that she was not pleaded on this attack. It's coming in the evidence. She has pleaded that this attack by brother and all. In petition where she has stated. You have not read that, no? Para 3, you have not read that. What now you have read in para 15, 14 and 15, whether it is bleeding is there. But you have cross-examined her. Cross-examination, what she has stated.
Your what?
Cross-examination.
No, you give it.
Yes. She has remarried. Remarried. Where is the cross examination related 26/5/2012 incident? 26/5/2012, brother of the respondent Nagaraj has made an attack. On that, where you have cross examined, you read. See? 04 of file by what happened? Go on reading. What you wanted to submit, you submit, then read, no, how it is relevant. And translate also. Go on reading Kannada, how you have to understand. You have to translate.
Name none for respondent arguments heard. Cases to delivery of, reserved for delivery of the.
Thirty-three. Abhishek, Varun member.
Wait.
What happened? Is still without electricity, surviving.
Order it.
What survives? Nothing. Huh? That you should have said, no. You made us read everything. You're sitting, standing silently. Huh?
Civil court, they let the owner send.
That has been granted. Huh? This mark there says this intra-court appeal has been filed against an order dated 28th of June 2018, passed by a learned single judge, by which a petition prepared by the appellant has been dismissed. Paragraph. Lead counsel for the appellant submits that in compliance of the interim order dated
11/10/2018.
11/10/2018 passed by a division bench of this court, electricity connection has subsequently been supplied to the appellant. Therefore, nothing survives for adjudication in this appeal. Paragraph. The opposite submission is placed on record. Accordingly, the appeal is dismissed.
So, this is it on the.
My lord, I appear for the responding.
But I am for the appellate. But retrospective effect is given to the notification issue for amending the schedule to include the scheduled tribe. But the facts of the case are that the first respondent,
Yes.
Lord, the first respondent was appointed in the appellant's organization on 27/12/1998. Against ST quota, scheduled tribe quota.
Yes, sir.
Lord, he had claimed that he belongs to Nayaka caste. He did not belong to that caste because he belongs to caste called Parivara. The District Caste Verification Committee of Mysore, by its orders dated 28/12/2016, found that he did not belong to caste Nayaka and therefore ordered for cancelling the caste certificate.
Yes, sir.
That's I think, my lords, there is some problem with the network, my lords.
No problem.
My lords are hearing.
Yes, yes, please go ahead.
Not the Tahsildar, Mysore, cancelled the caste certificate on 26/7/2017.
Yes.
This was reported to the appellant because she had played fraud by submitting a false caste certificate at the time of his appointment. We have dismissed him from service because his appointment was void ab initio. He was dismissed on 5/9/2017.
Yes.
He filed a writ petition that came to be allowed on grounds other than which are urged by the petitioner in the writ petition. Lord, this Parivara was included in the definition of ST. Subsequently, on 15/3/2018, 15/3/2018 is the Central Gazette. The caste certificate is in question pertains to the year 1988. There may be several exclusions, inclusions in the list of castes by the central government from time to time. But as on the date when he obtained caste certificate for being submitted to me, seeking employment against the ST quota, this Parivara was not included in the list of ST by the central government. I am a central government organization. He sought relief in this petition before the learned single judge on the ground that there is some circular issued by state government pertaining to the services of the state government employees who have submitted such certificates. That cannot be made applicable to me. I am a central government company. Kindly see the impugned order of the learned single judge, wherein he gives page 14 may kindly be taken, my lord. The discussion, relevant discussion will be that. Learned counsel appearing for the petition submit that the petitioner belongs to Parivara caste. It is his submission that he belongs to Parivara caste, which is synonymous of Naika. And he has not suppressed this caste for the purpose of wrongful gain. Lords will kindly see the caste certificate which he had produced was for Naika caste, to which he did not belong. Submission of the counsel for the petitioner, which is recorded by the this on court, is that petitioner belongs to Parivara caste, which is synonymous to Naika. Version is changed. Our contention is noted in para 3. I would be troubling my lords for a few minutes reading that also. The learned counsel for the first respondent submit that the petitioner belongs to Parivara community, which was included in the scheduled tribe list only on 15/5/2018. It is an inclusion, which goes to show that as on the date of his appointment, the petitioner was not scheduled tribe. Rightly, the Tahsildar had cancelled the caste certificate, and on the basis of the cancellation of caste certificate, the first respondent is dismissed from service. On the basis of 15/5/2018 Gazette notification, whereunder Parivara was also included, he gets a fresh caste certificate. As on the date of issuance of the fresh caste certificate, that was correct because it had already been included. But not on the date on which he obtained certificate stating that he is a Naika. Kindly appreciate. He had obtained certificate stating that he is a Naika and obtained appointment against ST quota. After investigation, inquiry, District Caste Verification Committee had set aside his caste certificate. Advised the Tahsildar to cancel the caste certificate. Accordingly, Tahsildar cancelled the caste certificate. Once if that caste certificate goes, my order to dismiss him from service, which he had fraudulently obtained, would be justified. A subsequent change in the statute, gazette notification, or inclusion in the constitutional schedule would not enable a fraudster to obtain fresh certificate and then say that my order was bad. My dismissal order was long prior to that, based on the false caste certificate. The learned single judge has mistaken that it would be having a retrospective effect. It is not so. Inclusion of cash from time to time would not enable the part deeds to be correct.
Anything else?
The 2018 cash certificate obtained by the first respondent based on the latest notification issued by the central government would not substitute the initial cash certificate which has been cancelled by the authorities. That's it.
Yes.
My Lord, I appeal for the respondent. My Lord, the full bench of this honorable court, in the case of my Lord, I have furnished a copy to the court officer. Court officer friend. Year 2012 Karnataka, page 173.
Yeah.
My Lord, the relevant para would be my Lord 14. The ding page 12. What the court has said, my Lord, any caste which has been included as a synonymous to scheduled tribe, it is not that the new caste which has been included, therefore it will revert back to the 1950 order. Para 14 may be kindly seen, my Lord. The next page.
Yes.
May I read, my Lord. In these circumstances, in the middle of the order, my Lord. In these
No,
circumstances, para 14,
So far.
the
so
next
yes.
page, my Lord. After para 14, the next page would be originally, it commences, my Lord.
Page 12. Bottoms. Yes, originally left hand side.
Which we are, you are reading para 14.
My Lord, para is not 20, my Lord. 14, my Lord.
14
1 4.
begins.
1 4.
4 begins so far as.
Yes, yes, my Lord. So far. Then, my Lord, the next page would be originally or subsequent. In the top of the left hand side, my Lord. May I read, my Lord?
Yes.
Originally or subsequently are only elucidatory and clarificatory in nature. To sum up, after carefully coordination, we are of the conviction of the view that expressed by the division bench in Krishnappa and Rangaya case has to be preferred. In these circumstances, assuming that the vernacular matter omitted was included in the scheduled tribe in 1991, we shall nevertheless answer the reference by stating that every inclusion would have a retrospective effect and would therefore revert back to the presidential notification of 1950. It is not that the new caste has been included. It is a synonymous caste which has been included. Therefore, the full bench says that, my Lord, it reverts back to 1950. Parivara came to be included as a synonymous, as my friend rightly pointed out, that, my Lord, in the year 2018. It is not a new caste which has been included. It is a synonymous to Naika.
No, that's correct. But he sought the appointment as saying that I belong to Naika caste.
Naika.
He did not say that I belong to Parivara, which is yet to be included. He did not say that
I fully agree with that, my Lord.
No. We would have understood if he would have said that I belong to Parivara and therefore I am a scheduled tribe. And then later, if this notification would have come, that would have inured to his benefit.
Obviously, my Lord.
Yes. Yes, please. What do you rely on this full bench?
Including the 1915 Procedural tribe order of this implementation. Dot point is not the report number 1 was appointed on 27/12/1988 as a sub-lot under the SC category, not producing a certificate stating that he belongs to Nayaka Baccash, which comes under scheduled tribe category as per 1950 order. You will also make kindly see, my lord, page 7, along with just I will read page 7. This is the Constitutional Scheduled Tribe Order 1950. Lord, entry 37, 38, like I can see. Entry 38. Nayaka, Lord, Nayaka caste is included in the scheduled tribe category, my lord, in 1950 itself. Subsequently, there is an amendment to this order on page 9, like I can see. Page 9. So far as Karnataka is concerned, page 10. Entry 37 may can be.
What? Just the constitution.
1950. Order which shows that entry 38 plot will cast Nayaka is shown as a comes under scheduled tribe category.
Yes.
Subsequently, plot there is an amendment page 9. Page 9. Some of the synonymous names are from Malad Nayaka left out. Hereby, Lord, subsequently this amendment plot page 10 may can be seen. Entry 38. Nayaka, Chola Nayaka, Nayaka, Kapadia, Gota Nayaka, Nana Nayaka, Veda, Almiti, entry 38. But even after inclusion of certain synonymous names in entry 38 itself, again, Lord, some of the names were left out.
So where was this amendment?
It is not 1981. It is what 1981, 1984, 1981. Subsequently, not there is one more amendment that is page 11. Page 11.
Here, they keep open. Really don't understand. Really despite. Yes. What this by this amendment?
Some of the synonymous names of Nayaka communities which were left out during 1950 were
They were
included. Then, my lord, kindly see page 11. Again, there is an amendment to scheduled tribe order. Wherein, my lord, kindly see, my lord, item number 2, an entry 38 for the words Nayaka, Nayakuru, Nayaka. The words in brackets, Nayakuru, Nayaka, including Parivara and Alavara are be substituted. Sorry.
You are going at a
Sorry.
super fast.
Sorry.
We have to let us reach there.
Yes.
Where are you reading? Which page?
Each note along with that.
So which page?
Page 11 mechanisms.
38.
38. Then you will also mechanism the section 2 in the Constitution Scheduled Tribe Order 1950. In entry 38 for the words Nayakadu, Nayaka, the words and brackets, Nayakadu, Nayaka, including Parivara and Kalvara shall be substituted.
No. So this past Nayaka is a scheduled tribe, right? You claimed that you belong to Nayaka, therefore you are a scheduled tribe.
Yes.
And that caste certificate was issued. Right.
Yes.
So your submission is therefore your appointment was correct. So then how have you got subsequently this caste certificate that you belong to Parivar?
After 24 years of service, Lord, the appellant hearing insisted me to produce trust caste certificate. That trust caste certificate I produced, Lord.
What happened by this 2020 page 11?
Page 11, even the Parivar is also included in the scheduled tribe category. Parivar. This is by way of substitution. So my respective substitution is brought, just I narrate, Lord. After 24 years of appointment, the appellant Lord insisted me to produce fresh caste certificate. I produced a fresh caste certificate, Lord, stating that I belong to Nayaka by caste. The state caste certificate was referred to DCVC, that is District Caste Verification Committee, Mysore. The District Caste Verification Committee, Mysore, Lord, without holding proper inquiry, came to the conclusion that I belong to Parivara by caste. So I don't come under scheduled tribe category. Against the order passed by DCVC, I filed appeal forward before the appellate authority. And this is the next case.
When was this order passed by?
This order was passed by
District Caste Verification Committee when?
Plot 18/12/2016.
So it is tell that you don't belong to.
Says that I belong to Parivara caste, so I don't belong to Nayaka. But against this order, I filed appeal before the appellate authority and extended case. May kindly listen for a minute. The appellate authority will exercise the order filed with DCVC and the matter is remanded to the DCVC for press consideration.
The date of the order.
Date of the order is kindly see this is 22/2/2018. Appellate authority order annexed, yes, case 66. Lord, after remand brought till today, no order is passed. Number one. Lord, based on the DCVC order, the Tahsildar cancelled the caste certificate, and because of the cancellation of the caste certificate, Lord, the appointing authority needs to take leave and dismiss you from service on the ground that, as per DCVC order, I belong to Parivara. Thereby, Lord, you can't claim reservation under ST category. My respective submission is brought. This caste Nayaka
So in any case, till today, yes, there is no determination. Right?
pending consideration.
Yes, Mr. So, in the absence of any consideration,
So Sitaram,
Mr. So have you heard what was argued that there is no, as on today, there is no determination of his caste because that order of DCVC has been set aside.
On a
By the
technical ground, it has
appellate
been set aside, my lord. I'm sorry to
Ah.
intervene. That all 4 members have not signed, therefore what the DCVC, the
Whatever.
appellate authority has said, let the matter go before the
We
appellate
are
authority.
asking in counsel for appellate. So
He is more enthusiastic.
No. I am not
Very-
enthusiasm. I am placing the facts. My
Yes,
learned
yes.
friend appearing for the respondent did not disclose on technical point and a matter was remanded.
No, but whatever the fact remains, it's a remand.
Please, my lord, please, my lord, please, my lord.
Then yes, Mr. Rao.
I leave it to the court. For
So
simple,
therefore you have to await the decision of the, no. Therefore, at this point of time, you have to await the decision of the committee. We will grant the liberty to you to take action, depending upon the outcome of the committee.
the committee order is of no consequence for this simple reason. I am only admitting that Marad in 1988, he claimed that he is an icon, produced the false caste certificate. I am attacking the foundation.
No. We will continue after the break, but he has referred to that scheduled tribe order in which Naika is a scheduled tribe.
But Naika is a scheduled type, but he does not
Ah.
belong to caste Naika. That's the issue.
Okay, Mr. But
His Parivara is also included.
no, please, Mr. Rao, please appreciate the basis of the initiation of action against him is order dated 28/12/2016 passed by DCVC, correct?
Yes.
So
Yes.
once that order is set aside,
Yes.
how can your termination stand? Once that order, whatever reason is set aside, order dated 28/12/2016 is set aside in appeal and the matter is remitted and until this question is adjudicated, what can we do? We can reserve the liberty to you to saying that depending upon the outcome of DCVC, you will be at liberty to initiate if this committee holds that he doesn't belong to scheduled tribe, then perhaps you are right. The basis of taking action against him has disappeared, right? It is founded on an order dated 28/12.
I think I have not made myself clear to the bench.
We will continue after the break. Who appears for this one? To get the opportunity, right? And argue the case in their absence. Best opportunity. Or It is 2 weeks, Your Honor. Serial number 47. Why see 46 all cases after 2 weeks? And to make a prayer on behalf of everybody. Why trouble in all these? These people are waiting. You are not there, right? In the afternoon, going somewhere to attend. Which case?
Serial number 47, Your Honor.
Why? Have you told the counsel for respondent that I will be making an adjournment, prayer for adjournment and see what is the time? See the time. Did you tell it?
He may be waiting, he will come and make a complaint. It's better in his presence if you make.
You make a submission in his presence, right? We don't. You call him at 2:30 and make a prayer for adjournment in his presence. Will it?
Thank you. Thank you.
Yes, Mr. Rao.
Lord,
Ah.
I had submitted to my lord that on the basis of caste certificate obtained by him in the year 1998 as Naika, he had been appointed. Now, the learned single judge relies upon the caste certificate obtained on 17/5/2018 as per Annexure U at page 71. Allows their interpretation. Kindly page 71, my lord. I don't know what he is seeking for remand. Page 71. Fresh caste certificate obtained by him and produced before the Honorable High Court. On this basis, reinstatement is ordered.
Correct.
That cannot be done.
Cannot be done. Correct.
That what kind of appeal he is referring to, I don't know. Then how he could obtain 2018 certificate if he has challenged the DCBC order? He could not have obtained, madam. Therefore,
Yes.
my lord, my submission to my lord should be to examine whether I was justified in relying upon the cancellation of caste certificate by the Tahsildar, saying that he does not belong to Naika and he is a Parivara.
Yes.
There is nothing wrong on my part. This 2018 certificate was not the basis on which he was appointed, and he is not seeking for fresh appointment on that basis.
Yes.
Therefore, my lord, the reinstatement could not have been ordered by the learned single judge. If for any reason, my lord think that this needs to be examined by either the appellate authority or DCVC, the reinstatement order cannot be implemented.
Yes.
Subject to outcome of that, the decision will have to be taken by the appellate. Please.
That's all.
That's.
Yes. You have already argued, right? He is rejoinder submission.
No, my lord, there is one decision of a division bench of the Sound Court in case of Canara Bank versus Shailesh.
We should have said 2 o'clock, right, to finish. You have got a new energy, new lease. Again, argument for half an hour. This is a new procedure, right?
But in this case, DCVC had not been constituted. That fell for consideration of the division bench. The division bench directed the state to constitute DCVC, and DCVC was directed to give a decision on the matter within 3 months. In the meanwhile, my lord, the single judge's order was set aside insofar as it relates to reinstatement into service.
Yes.
That's the basis. The final order is that the appeal is allowed in part. Direction issued by the learned single judge to reinstate first respondent is quashed. First respondent is directed to appear before the caste verification committee with a copy of the order and seek for disposal of the matter as expeditiously as possible, but not later than 2 months from the date of receipt of the copy of the order. That's my suggestion.
No. Yes. Yeah, argue, please. We will have to hear him again. This is a new trend we are setting, that after concluding, since it was well past lunch, again you get a right to revive, and you had concluded, right? Point out. No, no, you should be satisfied that we have heard. Point out whatever. We will hear him again. Now, please argue. What pointed out? Third time you are telling us. Third time you are telling us attain the age of superannuation. Single judge has also said, third time you are telling us, we can't help it, right? We cannot make you younger and reinstate. That's beyond our power. Aware means, what do you think? He has not read the order passed by learned single judge? He has, learned single judge himself has said that petition attaining age of superannuation this September.
Yes.
Yes. Anything else, Mr. Senior Counsel, for the appellate?
That's my submission. Whether 1988 caste certificate is valid, whether I committed any error in dismissing.
That we will answer right
Please.
away. Yes. Actual paragraph. Learned Senior Counsel. Learned Counsel for the appellant. Learned Counsel for the appellant submitted that learned single judge ought to have appreciated that the employee had produced a false caste certificate at the time of joining the services of the company, and had disclosed that he belongs to Naika caste, which is a notified tribe. It is also urged that the single judge, on the basis of the caste certificate obtained by the employee on 18/12/2016. 18/12/2016 could not have directed reinstatement of the employee in service. It is further submitted that in any case, the aforesaid question ought to be considered by District Caste Verification Committee. In support of aforesaid submission, reliance has been placed on a division bench decision of this judgment dated 22nd July 2010, passed in WA 6173/2010. On the other hand, learned counsel for the paragraph. On the other hand, learned senior counsel for the employee. No. First he argued, Mr. Learned counsel for respondent number. Learned counsel for respondent number 2 to 5. He should argue first, right? You he's testing respondent. So then delete paragraph. Learned senior counsel for respondent number 1. Just a minute. Yeah, all right. Learned senior counsel for respondent number 1 submits that against the recommendation, against the order dated 28/12/2016, the employee had filed an appeal before the appellate authority. The appellate authority, by an order dated 22/2018, has set aside the order dated 8/12/2016. It's not 28/12, it's 8/12, right? Earlier we have written 28 somewhere. Facts. Huh? So earlier this DCVC made a recommendation on 8/12. Not 20. So order dated 8/12/2016 passed by DCVC is set aside, and the matter has been remitted to the District Caste Verification Committee to ascertain the caste of the respondent. It is further submitted that no decision thereafter has been taken by the District Caste Verification Committee. Full stop. Paragraph. Learned, it is submitted that the order passed by the learned single judge does not call for any interference. Paragraph. Learned counsel for respondent number 225 has submitted that subsequently submitted that by an amendment submitted that by an amendment dated what is 91? 91, right?
No.
By amendment made
No.
to the Constitution Scheduled Tribes. By an amendment made to the Constitution Scheduled Tribes Order 1950, the word the community Naika has been included in the scheduled tribe. It is further submitted that the aforesaid order has the aforesaid inclusion shall apply with retrospective effect. Therefore, the respondent number 1 is a scheduled tribe and has full stop. In support of aforesaid submission, reliance has been placed on full bench decision of this court in so and so versus so and so paragraph. We have considered the submissions made on both sides and have perused the record. Full stop. Before proceeding further, we have considered the rival submissions made on both sides and have perused the record. Full stop. The office order, full stop. The employee had assailed the validity of the order dated 5/9/2017 by which his services were terminated in the writ petition. Full stop. The relevant extract of the order dated 5/9/2017 is extracted below for the facility of reference. Is page 26, bracketed portion, paragraph. Thus, from perusal of the relevant extract of the order of termination, it is evident that the same is based on the recommendation made by the District Caste Verification Committee. Full stop. The recommendation made by the District Caste Verification Committee dated 28/12/2016. What is the date, Mr. 8/12 or 28/12? No. It's somewhere it is 28/12 in the order. So recommendation of the District Verification Committee dated 8/12/2016. The aforesaid order is no longer in existence as the same has been set aside by the appellate authority. Same has been set aside by the appellate authority by an order dated 22/2/2018, and the matter has been remitted to the District Verification Committee to decide the matter afresh within a period of 45 days. However, the caste of the status of the employee has not been determined by the District Caste Verification Committee. Full stop. Paragraph. So in view of aforesaid, we set aside the order dated 11th for the aforementioned reasons, right? The order dated 11th of September 2018 passed by learned single judge is set aside. the order of order of dismissal of the services of the employee dated 5/9/2017 is also set aside. The district caste verification committee is directed to decide the caste status of the petitioner within a period of 2 months from today. It is expected that district caste verification, directed to decide within 2 months from today. To stop depending upon the decision which may be taken by district caste verification committee, it would be open for the insurance company to proceed against the employee if so advised. With the line below, with the aforesaid directions, the appeal is disposed of.
Allowed.
No, you argue, you are there to argue. Parivara. You are what you have Parivara.
By amendment,
By
Parivar word has been
Parivara.
mentioned.
Instead of Naika Parivara. Yes. Fine. That's for district verification committee to decide.
Certified. The jury can yes.
So, what adjournment? None for the appellant, Mr. Pavan Chandra Shetty, learned counsel for respondent, learned counsel for respondent, praise for adjournment, list next week.
37. Okay, Shakti.
36. Huh?
Please repeat it.
Oh,
Start that.
When? No. When do you want? Because it has to be governed as per your convenience, right? So tell us when. We are asking you a date, 1 week, 2 weeks. We don't know when your senior will come back. So what next week, after 2 weeks, after 3 weeks, whatever you say. 2 weeks, 1 week. What's your name? At least you can tell us that, right? Write down. Mr. So-and-so learned counsel for the appellate, praise for adjournment on the ground that arguing counsel, Mr. None for respondent. Arguing counsel, Mr. So-and-so is out of station. List after 1 week. 1 week.
38. DC Sitaramra. AB Narayan Swami.
Lord, I am for the appellant.
Huh.
But here I have challenged the order of the learned single
1
judge.
minute. You are ready, right?
Yes.
Ready? 1 minute. Give us 5 minutes. Yes.
But the employee was dismissed on the proved charges of misappropriation of funds of a account holder in the branch. One Arjunappa had an account with the appellant where the employee concerned and another clerk by name Joshi were working. They planted one B. Narayan Singh to submit withdrawal slips, withdraw the money, and then they share. Both these employees who are found guilty is compulsorily retired by the bank. They were not dismissed because they could not have retained in the branch where they were misappropriating the funds of the customers of the bank. Being a financial institution, we took decision to compulsorily retire them from service. Joshi accepted and happily he is drawing pension. The petitioner may also be drawing the pension now. But he raised a dispute before the Central Government Industrial Tribunal. Dispute came to be allowed. I challenged that order in WP 4648 of 2015 before the Sun Court. My writ petition is rejected. But not a legal order, of course. Para 10, in page 17 may kindly be seen. That's where Narayan Singh had confessed that this Chavan and Joshi had helped him to advise him to withdraw the money. They gave him small money. These two people divided higher amount of money out of the illegally withdrawn amount. That is a confession statement, is at exhibit M25. I could not secure the presence of Narayan Singh, who had given confession statement before the inquiry officer, for the reason that he had gone back to Rajasthan from hospital. He was working for another customer of our branch. After this episode, he left to Rajasthan and resides in Rajasthan. We could not trace him or get him before the inquiry officer. But to prove the content, signature, and the veracity of the contents of M25, the confession letter, I have examined 4 independent witnesses who were present when he voluntarily gave statement as per exhibit M25 before the inquiry officer in a departmental inquiry, where strict rule of evidence like criminal case cannot be applied. Preponderance of possibilities ought to have been seen. Kindly see, it is not as if I just produce a letter and say through my manager that this is the letter Narayan Singh gave, therefore hold him guilty. That is not that. I have examined independent witnesses also before the inquiry officer. That part of it is not dealt by the MW5, MW6, and MW7 management witnesses. These 3 witnesses deposed about exhibit M25, presence of Narayan Singh, writing of the letter in his handwriting, subscribing his signature, and stating that he is voluntarily giving that statement.
What are their names? MW5 is the name. MW5.
One second, I'm sorry, Miller. And,
Page 114. List of, yes. Page 114.
Murali, the record,
114 page.
Pujari, yes. SM Pujari. Then, my lord, MW6 is MKG Jain. MKG Jain. Mahendra Kumar G. Jain. Employer of Narayan Singh. For question number 6, he says Sri Narayan Singh was an employee of our firm at that time. For question number 7, he says, please confirm that Sri Narayan Singh signed this letter before you. He said yes. In the cross examination also, he confirms. I do not generally sign as a witness for an unknown person. Since Sri Narayan Singh was well known to me, I signed as a witness to him.
So please point out from the this thing, inquiry report, where he has admitted.
But M25, exhibit M25 is the letter given by
Page number.
It is in handwriting. M25.
Not on record, Mr. M25. Is it on record? We want to see what has he said. Not on record. Thank you. This is the inquiry report, right? That he has to. Let him argue. He just asked whether exhibit P25 is on record or. Yes.
But it is in the LCR also, brother.
LCR.
Of the CG80 where it is produced.
Not
Otherwise, my
LCR.
lord, give me some time. I will produce the typed copy along with this photocopy of the certified copy, which is in my file, my lord.
Current counsel for the applicant. How much time?
My lord should kindly have it on 28th. My lord.
Whatever time.
No, 28th would be.
Current counsel for the applicant place for adjournment in order to enable him to place on record the copy of typed copy of exhibit P25.
M25.
M25. List on 28th March.
Number 39. Number 10.
Is the council correspondent?
I apply for respondent, your lord.
We ready? Yes. Yes. Where is the notification? What page? Fourth of October.
835, note 11, page 37. Wherein eligibility has been fixed. Wherein it clearly says not wherein minimum 4 years service has to be rendered. The regular service rendered in the regular post.
Page 9.
So the annexure D is page 35 notification. Relevant page
He wants to argue first. Let him argue.
I'm sorry. I'm sorry. I thought.
Mr. Mr. Subramania Bhatt is there.
I'm sorry.
He is arguing.
Yes.
Yes. So your appointment was not against a permanent post, right? But that is not your case before the learned single. This is what, read the order. What have you argued and what it has been held? The dispute is only you wanted this post to mean temporary also. Read para 2. Where you are reading? No. 49 is in Kannada. Is table. Section G. Karnataka Electricity Board regulations. Which regulation? That's 53, page 53. That's it. Yes, Mr.
Yes. Lord, in terms of the notification, Lord, wherein this post was called for recruitment for the post of assistant, Lord, wherein the requirement eligibility criteria, Lord, is fixed that notification annexure D, Lord, internal page 3. Annexure D is at page 35, Lord, 11 page 37. But it is in Kannada, Lord, wherein It clearly says that ಯಾವುದೇ ಕೆಳ ಹುದ್ದೆಗಳಲ್ಲಿ ಈ ಅಧಿಸೂಚನೆ ದಿನಾಂಕಕ್ಕೆ ಕನಿಷ್ಠ ಒಟ್ಟು 4 ವರ್ಷಗಳ ಸೇವೆ ಸಲ್ಲಿಸಿರಬೇಕು.
You have worked on the post of Mr. Which post? You have worked as on the post of assistant for. Not on these posts for 5 years, right? That's the admitted case that if this probationary Mazdoor is excluded, then you are short 2 months. Correct? Yes.
Lord, he was earlier, of course, Lord, he was working as probationary Mazdoor, which was a temporary post. Lord, he was regularly appointed in the post of junior lineman on 10/4/2013, my Lord. And after regular appointment, my Lord, he was given with a promotion in the month of May 2016 as assistant lineman. And wherein, my Lord, 2016, my Lord, May 2016. This notification was issued on 4/1/2017, providing benefit to the even in-service candidates, Lord, wherein the persons who have put in more than 4 years service, Lord, they were given the opportunity to participate in the selection. But as per the requirement, 4 years of service, Lord, wherein petitioner is not put in. And in regard to, Lord, the earlier service, that is worked as a gangman or a probationary Mazdoor, there is a clear clause in the notification that that service will not be considered for the purpose of considering 4 years service. It is at in place 37, Lord, the notification. In regard to that part, is Lord, it is not challenged. And single judge, Lord, considering these eligibility criteria, rightly writ petition has been dismissed. That in regard to 4 years service is concerned, as on the last date of application is concerned, he had not put in that period of service. For that reason, Lord, he was not eligible to be considered for the purpose of recruitment to the post of assistant. And accordingly, Lord, liberty was given to the petitioner by the learned single judge to appear in the next recruitment process.
You appeared.
And next is R5 is the service certificate, Lord, wherein his service has been considered from 23/2013.
Anything else? Yes. This intra-court appeal. This intra-court appeal arises out of an order dated 10th of October 2018, passed by learned single judge, by which writ petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of this appeal. Please stated up that the appellant was employed, and was initially appointed as probationary Mazdoor in the establishment of the respondent on 30/10/2006. Thereafter, on completion of 5 years of service, the services of the petitioner were absorbed on the post of junior lineman with effect from 20th March 2013. Thereafter, the applicant was further promoted on the post of assistant lineman on 2/7/2016. Full stop. A notification dated 4/1/2017 was issued for filling up the post of 13 for filling up 13 posts of assistants. Full stop. The aforesaid notification contained a stipulation that contained no clause 1B of the aforesaid notification. Clause 1B of the aforesaid notification contained the following stipulation. Clause 1(3) of the notification. Clause 3 Clause 3 of the notification provides for delete. Clause 3 of the notification. The aforesaid notification also provides for required eligibility criteria for appointment to the post of assistant. Full stop. Clause 3 reads as under. Services rendered. The appellant who was not eligible for consideration in the light of aforesaid condition of eligibility, filed a writ petition challenging the validity of the challenging clause 3 of aforesaid notification on the ground that the same is ultra vires the provisions of regulation. AEB recruitment and promotion regulations. Regulations. Full stop. The learned single judge, an order dated 10th of October 2018, has dismissed the writ petition inter alia on the ground that the petitioner has not completed four years of service in any permanent lower post. Full stop. In the aforesaid factual background, this appeal has been filed. Learned counsel for the appellant. Learned counsel for the appellant while inviting the attention of this court to so and so regulation, Karnataka Electricity Board recruitment and promotion regulations. There are regulations has submitted that the aforesaid regulation do not prescribe that a candidate should have served for a period of 4 years on any lower post which is permanent in nature. Therefore, lower post which is permanent in nature. Therefore, learned single judge grossly erred in dismissing the writ petition. On the other hand, learned counsel for respondent has pointed out that subsequently the appellant was considered for promotion on completion of 4 years of service has been subsequently promoted. Paragraph. We have considered the submissions, or where is the post defined, Mr. in the regulation? We have considered the submissions made on both sides and have perused the record. Regulations, copy of regulations you have. Relevant, not whole thing. The expression post must have been defined in the regulation, Mr. What is the post? What does post mean? Post means what? Give it. Where is this relevant, this thing, Mr.? Which flag? Yes. 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 The relevant extract of the regulation which we have considered submission made on peruse the report. The relevant extract of the eligibility criteria for the post in question, for promotion to the post in question, reads as a this 1, 2 right here. Paragraph. Thus, from perusal of the aforesaid eligibility criteria prescribed under the regulation, it is evident that an employee should be on a probation for a period of 1 year and should have completed 4 years, 6 years of service in any lower post. We are informed that the aforesaid requirement has been subsequently reduced to 4 years. Full stop. Therefore, the employee must continue. Therefore, it is thus on conjoint reading of all the clauses prescribed in the aforesaid eligibility criteria in the regulation, it is evident that the employee should continue on a permanent post and not temporary post. Services of an employee on completion of probation for period of 1 year can only be confirmed against a permanent post, and probation of 1 year can only be confirmed against a permanent post. Therefore, the contention that the condition contained in the notification is contrary to the rules does not deserve acceptance. Full stop. In any case, it is noteworthy that in any case the appellant has subsequently been promoted. Paragraph for the aforementioned reason. It is noteworthy that appellant has been subsequently promoted to the post on completion of service. Paragraph for the aforementioned reasons. The contention that the requirement in the notification is contrary to the regulations, not rules, no regulation, does not deserve acceptance in the result appeal phase and the hereby dismissed.
Obliged.
What is appearing? Yes. Srimati HR Renuka, learned counsel for the appellant and correspondent argument served, judgment signed and dictated in separate sheets. This intra-court appeal arises from an order dated 5th of October 2018, passed by learned single judge, by which a writ petition preferred by the appellant has been disposed of. Paragraph. Facts giving rise to filing of this appeal briefly stated are that respondent was employed as a conductor in Karnataka State Road Transport Corporation, hereinafter referred to as the corporation. Full stop. On 15/5/1997, while the respondent was discharging his duties as a conductor in a bus flying from Mahadeshwara Betta to Shimoga, the checking staff of the corporation subjected the bus for inspection. At the time of inspection, it was found that the respondent failed to issue tickets to two passengers and had not collected the requisite fare of ₹5 each from them. Paragraph. On the report of the checking officials, disciplinary proceeding was initiated against the respondent and articles of charges were issued to him. Full stop. Thereafter, a departmental inquiry was held against the respondent, and by an order dated 18/10/1998, a minor penalty of punishment by reducing one increment with cumulative effect was imposed. Full stop. The respondent, after a period of 15 years, raised the conciliation proceeding, and on failure of the same, the appropriate comment by an order dated 28/8/2012 referred the dispute under section 10(1)(d), small d, 1D of the Industrial Disputes Act 1957. Full stop. The tribunal passed an award dated 14/7/2014 by which the punishment was set aside. Full stop. The corporation challenged the aforesaid award in a writ petition. The learned single judge, by an order dated 5th of October 2018, inter alia found the inter alia agreed with the contentions raised by the corporation. Full stop. However, the learned single judge declined to grant the relief on the ground that uh, that that in case the relief as prayed for by the corporation is granted, the corporation would be benefited by few thousands only, which is not a substantive relief. Accordingly, the petition was disposed of. In the aforesaid factual background, this appeal has been filed. Paragraph. We have heard the writ counsel for the appellant. None has appeared on behalf of the respondent. Stop. Paragraph. From the perusal of the record, it is evident that that in a departmental inquiry initiated against the respondent on a misconduct was found to be duly proved against him, and thereafter, thereafter, the disciplinary authority had imposed the punishment of stoppage of one increment with cumulative effect. Cumulative effect. Full stop. The learned single judge. Full stop. The respondent employee accepted the aforesaid penalty. However, belatedly after a 15 after belatedly after a lapse of about 15 years, the respondent chose to challenge the penalty imposed on him by by initiating conciliation proceeding. Full stop. The learned single judge has agreed with the contentions of the appellant. However, uh, however, learned single judge has heard, learned single judge ought to have appreciated that the penalty was imposed on the on a misconduct which was duly found proved in a disciplinary proceeding, and the relief could not have been denied to the corporation only on the ground that it will benefit the corporation only by few thousand rupees and is not a substantive relief. Paragraph. For the aforementioned reasons, impugned award dated 14/7/2014 passed by the Labor Court is set aside. No, for the aforementioned reasons, the order dated. The operative portion of for the aforementioned reasons, operative portion of the order dated 5th of October 2018 passed by learned single judge is set aside. Right? Thereafter, right, the order passed by the the award dated 14/7/2014 passed by the Labor Court is also set aside. Line below in the result appeal is allowed. Okay. Yes. What is the date of birth of the? 3/4/2000. What is she doing? Final year. No compromise arrived at between the parties. Oh. Obviously, you can't go now. Ah,
When he promised that he will take back the excellence of he will take
huh? Astrologer. He must have told you then. Huh? So you ask him and tell us what would be the result of this appeal. Huh? Tomorrow you find out what would be the result. If he can tell you to file a case, he can very well tell you what will happen. Huh? No, no. No, so you did not consult an astrologer, right? Ah,
years you only answered what she was saying in the presence of what is my everything else is the child. Then some or communication.
when was the petition filed? When was the petition filed? What ground? the ground of cruelty and desertion, both. What is desertion? Which paragraph? What? Desertion, reading which paragraph? Cruelty, which paragraph? So this petition was filed on the ground of cruelty and desertion. So what is the cruelty pleaded, madam? Which paragraph? Desertion, where what is no, what is the case pleaded? Then we will come to the proof, right? What is the case pleaded? Which paragraph? That's what we are asking. Which paragraph? What has been pleaded? Like cruelty. What he has said about what does it amount to cruelty when desertion has taken place? Where has he said? And decree has been granted on both the grounds, cruelty and desertion. Hours.
Oh, from the petition, we wanted to know. What from the judgment? 6 onwards. Page.
last ones. Please move that. And the child was always accompanied. And all of it, it's- one day, his mother, they have this is a yes, it's that it is posted to bucket and expanded service. Closing the door and locking the mother. He listened to the page number. In this there is ground floor and first floor. In the first floor, there is another 2 rooms. Who are staying in the first floor. She locked home and went to her with the child. After they made it clear, yes, she locked long. He himself says in the first floor there is another 2 rooms. I was staying in the she had to lock down and she had to keep it. If she had locked that self is another. They said in 2003 December, she went to ceremonies. in December, I think draft funding, draft for year. He only goes and draft. And he gets the many days. So, till 2000, he has taken up. And he just that she go regularly. And he was purely love. There is no any star, and any to be managed. More than it's also so how he makes it. I know college of and yes, it is not due to suggest that it's colleges only in November 2009. Now, it started. He was consulting with from a candidates. They are responsible. This case they will. This somewhere 2009. We decided in somewhere 1 month to have a consent course degree and said to my cousins, they I to that. Here is it. I sent words my inspiration. But in action, can see now, but vision for perception. Yes. The two witnesses find out. One witness is Radha. Uncle, he says that she after the work is so many months away. Today, we try to constant good. These are the Is now eight. Somebody decides to go. In November, he says. I don't know. Well, ask her not that she will have everyone you need and then this that and
Real relations. We'll continue tomorrow. Other hearing. Ah. Ah. Respondent. What's it? So and so. Learned 43. So and so learned counsel appears for respondent and prays for adjournment to enable him to file wakalat list after 2 weeks.
ಕೋರ್ಟಲ್ ಆಫೀಸರ್ 46 ನಂಬರ್ ಏನಾಯ್ತು ಸರ್? 46 ನಂಬರ್ ಏನಾಗಿತ್ತು ಸರ್?
Repeat, sir.